So I usually think of estate planning in sort of two phases. There's what I call your core estate planning, which are the death and incapacity documents that really everyone should have, not just a business owner. I'm talking about your will, maybe a revocable trust, a healthcare proxy, a power of attorney, things we'll dive into a little deeper later on. And those are basically, your basic risk management documents to make sure that your family is protected, taxes are minimized, the right personnel is in place if bad things happen, if you become incapacitated or pass away. And then the other type of planning that's sometimes relevant is what I'll just call tax planning, which usually involves gifting and setting up trusts or making gifts strategically to minimize usually estate taxes, but sometimes also income taxes, often in connection with a transaction. They're the ones I just mentioned. The core four, as I call them. You've got your incapacity documents. You've got a healthcare proxy, which is a document that allows you to appoint someone to make medical decisions for you if you're incapacitated. You've got a durable power of attorney, which is a document that allows you to appoint someone to make financial decisions, again, intended if you're incapacitated, unable to make those decisions yourself. And then you've got a will, which is the roadmap for what happens at your death, and often would cover both the situation if you're survived by a spouse and if you're not. And the will is where it shows the flows of your assets and also appoints important personnel like the executor and maybe a trustee for your children and maybe a guardian for your children if they're young. Often we have clients do sort of a more sophisticated version of a will, which is called a revocable trust or a living trust. It's really the same as a will. It has the same purpose. But if you do your estate plan in that form, you can avoid probate, which is the legal proceeding that happens at your death that can sometimes be time-consuming and expensive. And so if you can structure things to avoid that, that's a pretty common goal. Everyone needs the core four, right? But I think the question you're asking is when does the tax planning kick in? And that's largely dependent in some ways on the thresholds for when you have a potentially taxable estate. At the federal level, right now, as we sit here today, a married couple with under $27 million shouldn't have any estate tax to pay. That number may, at the end of next year, revert to where it was prior to 2018, which is about half that, 14 million. Some states, like New York, for example, have their own estate tax thresholds and their own estate tax, and you have to be mindful of what those limits are as well. But if you're under those limits, comfortably under those limits, you probably don't need to worry about doing any gifting because you'll retain all of your assets, and then when you pass away, your spouse or children will inherit them, and there won't be any death tax, estate tax. But if you're over those limits, you may want to take steps to reduce or mitigate those taxes. But depending on what your spending needs are and whatnot, there is sort of a financial planning exercise that needs to go into this, because if you're going to be doing gifting, by definition, you're probably going to be restricting the assets you're gifting, and they're not going to be quite as accessible or accessible at all to you for your own spending needs. So if you spend a lot of money, you may need to keep all of your money and all of your assets and not gift any of it away to your kids or your spouse and kids, because you would harm yourself financially even if you're saving taxes. The classic situation is in advance of a transaction, but hopefully far in advance of a transaction. So the benefit of gifting for business owners is that what you own is a private business that may, depending on what you're gifting, be able to be valued at a pretty significant discount to its actual value. So let's take the example of someone that has a vet practice that they think they could sell for $20 million. And they want to gift a 10% interest in that practice to their child. If you do the math, you think that you're making a gift of $2 million, 10% of 20. But an appraiser will come in and say a 10% interest in a private business is not worth $2 million because the owner of a 10% interest has no control and is really stuck owning that it's a non-marketable interest. They can't sell it. They have no control. They can't sell it. And those discounts often can aggregate to almost typically 35 to 40%. So that $2 million interest, an appraiser might say it's only worth $1.2 million. And since there's a limit on how much you can gift, those are those estate limits I was mentioning before, those are also the limits to what you can gift. By gifting private stock, you can actually gift more, on a sort of post-transaction basis, by taking advantage of these discounts. The mistake that people make, though, is that they wait too long. They don't think about the planning until they've already signed a term sheet and the deal is going to close in 3 months, and then either they're rushed into making decisions, or sometimes the transaction is so far along that you really can't do the planning anymore and take advantage of the discounting. A really good question, and I have to say that the only knowledge I have about that is that I Googled the question, and at least according to Google, there are about 15 states where a non-veterinarian can own a veterinary practice. And clearly, if you live in one of those states, then you can probably make gifts of your practice to trust for your kids or your spouse or something like that. If you live in one of those other states, I think you need to consult with your veterinary practice lawyer, because my understanding, again, from Google, is that there may be some workarounds. There may be ways to structure it. But that is definitely a very important issue. Before you spend a lot of money hiring an estate lawyer to come up with some fancy plan to save taxes, you really need to figure out if this is even viable for a veterinary practice. I think another area of planning that's not really tax planning per se is what you might call succession planning, where someone dies. The question is, most if you have two veterinarians who are in business together, and one of them passes away, and that person, the person who passed away, their spouse, is either prohibited from owning the practice because they're not a veterinarian, or the remaining owner doesn't really want to be in business with his or her deceased partner's spouse. You need to have kind of an exit plan, and we call that business succession planning. And typically, the way that can work is that people get life insurance. The life insurance pays out. Sometimes, each owner would own life insurance on the other owner, so that if you and I are partners and I die, you have life insurance on me, which gives you a bunch of money. And then you're obligated to use that money to buy out my interest in the business. So you end up with the whole business, but then my spouse ends up with cash, which is sort of the right result. This is something that your estate lawyer or even your business lawyer can structure, and it's very important when you have multiple owners. So I think the fact that the listener is listening to this is a good sign that they're focused on estate planning, and taking that first step of reaching out to someone whether it's your accountant or your corporate lawyer, uh, or your financial planner or financial advisor, and engaging in a discussion around estate planning and really taking a hard look at what you've done, modeling out what taxes might be, and then coming up with an action plan to actually uh, implement something. This is a real area of procrastination. No one views this as urgent because it's sort of planning for death and incapacity. Everyone thinks they're going to live forever, and that's just not the case. So I think building a team of advisors is important, and I think you know committing to a timeline for actually doing the planning and getting it put in place, and then reviewing it, every few years is also important to see if anything has changed. I think it's fair to say, and it's not a political comment, that generally the Republicans are in favor of lower estate taxes and higher exemptions, and the Democrats have generally been in favor of higher estate taxes and lower exemptions. And so if the Republicans are controlling the government, and really they would have to control sort of all three branches, I think that the the threshold for when you would need to really focus on taxes might be higher, right? So right now the exemptions are, at least at the federal level, that sort of 27 million. And if the Republicans control, they might continue that even beyond next year when the current law is supposed to sunset. And so if you're under that amount, you may not have to worry about doing much of the gift planning. You still need to do the core planning. But if the Democrats win and control three branches of government, or even if we have mixed government, then I think it's more likely that we are going to see that federal exemption cut in half. And so then your target for when you would need to do planning is probably more like 14 million. And so that may capture a whole bunch of other people. And so I think just paying attention to where those exemptions are is important. I think that could be affected or will be affected by the outcome of the election.